So we're going to talk a little bit, this is one of my favorite topics because I think people get a little confused about, why is intellectual property important to me when I'm starting up a business or when I'm thinking about how I'm going to commercialize my invention. And I think too many people don't think about it as a comprehensive set of things that you need to think about doing when you're in very early stages. And we're going to talk about some of the reasons why it's become, I think, more important for you to be thinking about it in the early stages. So this is one of our graphs that we like to show because it tells the cycle of innovation, but if I have anything to say about this, I think there need to be like spokes, so it's more like a wheel, because at any one given moment, if you're in the process of trying to commercialize an invention, you're doing all of those things. You're probably still doing your research and development. You might be trying to find some funding. You might be creating new ideas about the idea that you already created. And then you're doing licensing, marketing, and you may be thinking about your patents and your trademarks and your copyrights that go along with your invention. One of the missions of the U.S. Patent and Trademark Office, and one of the primary reasons why we went ahead and established regional offices in Denver, Dallas, Detroit, and Silicon Valley, as well as continuing operations, of course, in our headquarters in Alexandria, Virginia, is that we really felt the need to come out and talk to people where they're at, rather than making you come to us. In today's society, it's no longer appropriate for us to be the agency that people have to come to. We wanted to make sure that we were coming to you and getting information and awareness out about intellectual property. So one of the neat things, though, about this week, I like to call it World Intellectual Property Day week. So World Intellectual Property Day was April 26th. That's the anniversary of the date that the World Intellectual Property Organization Treaty was signed. And World Intellectual Property Day is, the whole reason behind it is to go ahead and increase awareness of intellectual property. And this year's theme is digital creativity. So I wanted you guys to know that because this fits in really perfectly with that whole celebration of intellectual property. So one of the things that we're going to do today is we're going to talk about the risks of early public disclosure. One thing that we've done recently, and actually over the course of my entire career, the U.S. has very slowly harmonized with the rest of the world in terms of how we protect our intellectual property. When I first started out all right, we're not going to name the year, but when I first started out, we were a first to invent system. We did not publish our patent applications. There were no provisional applications. And if you wanted to search prior art, you were going on a plane to Washington, D.C. to search wooden shoes. And the folklore about why we call it a shoe is because Thomas Jefferson, who was our first patent examiner, used to keep the first patent applications in his shoe boxes. So we kept that tradition. But that's what was going on when I first started out. The U.S. is now a first inventor to file. So he or she who wins the race to the patent office is deemed the presumptive owner of the invention. Which is why it is really important when you are starting up a business that you think about patenting your invention and protecting your intellectual property as early as possible. There is a grace period in the United States. We still are the only country in the world to do that. But one of the things that I'll tell you about that first invent, moving from the first inventor or first to invent system to first to file system, is that for big companies, they were always operating under a first to file because the rest of the world was a first to file system. So they changed literally nothing about their procedures in terms of gathering their intellectual property, looking at their invention disclosures, deciding when to patent. Nothing changed for the large corporations. But where the impact was really felt was in small businesses, independent inventors, and startups. Because now, instead of having that year period where you were able to get out there and sell and talk about your invention and gather some interest about that, maybe attract some funding, you really do need to think about having your provisional patent application or some sort of intellectual property protection in place before you ever do any of that. Because If someone else sees you at a trade show, or they see you in a crowdfunding campaign, or they see you out there at a conference discussing your invention, I guarantee you that if they win the race, it's going to be very difficult for you to go back and actually end up owning that intellectual property. It may very well be lost. When you publicly disclose before you file, you've always faced the loss of your rights internationally. And I know, especially when you have a disruptive invention, international patent rights are really important for commercialization purposes. Because, right, if you have a multinational company that's looking at your invention to license and, they want to make revenue from your invention, they're going to want to know that they can make revenue in every country that they're in. So if you've already lost all of your international filing rights, that's going to be a big discussion and may very well impact the value of the license. In crowdfunding campaigns, I think that's one of the places. There is no case law on that yet. I think we're going to see it soon, because I think that's going to be one of the places where people have operated maybe a little faster than the law has had a chance to catch up with them. Where to get help? Obviously, we want you to come to the Patent and Trademark Office. We are here to help. And I love saying that because, how many people from the federal government actually get to say that and mean it? But we do. We are here to help. Through educational and seminars like this, through outreach, through our office hours, through our website, we can work together and figure out how to get you where you need to be and help you understand the process, because it's not necessarily intuitive. Intellectual property strategy is a business strategy. So as Brad mentioned, one of the things that I did when I was at Oracle and actually throughout my career, including at First Data, which is my Omaha connection, I did all of the mergers and acquisitions work for those companies, probably to the tune of somewhere between $50 and $70 billion worth of deals. So if any of the companies that I worked for were wanting to be bought, you came through me, and I was the one that was looking at your intellectual property assets, your intellectual property story, and judging whether or not you had done things the way that you should have. I will tell you, intellectual property is attractive to investors and buyers for a lot of different reasons. One of the reasons that big companies get their patent portfolios or get their intellectual property in a row is because they want to be able to protect their revenue. Not just the revenue that they're making today, but the revenue that they're making 5 years from now. Because that's really your strategy when you're talking about intellectual property. Intellectual property ownership can deter infringement lawsuits. It definitely increases your leveraging power. There was usually some reduction on the buy price if the intellectual property analysis came back, where we said, they didn't do this right, and well, it's a mess. The other thing is, and this is more of a kind of experiential learning, but if the company that we were looking at when I was out in the private world actually had their ducks in a row on their intellectual property story, they had a story to tell, they had all of that other good stuff, that was usually the canary in the coal mine for how well everything else was going to work with the company. It was if they had it together on IP, they had it together everywhere else, because again, when you're talking about your intellectual property strategy, you're doing the blocking and tackling to make sure that your company is successful 5 years from now. And one needs to recognize, intellectual property is a property right that can add value to the company's assets. It's also global, but territorial. Developing an IP strategy, we actually have a really cool tool on the USPTO.gov website called the Intellectual Property Awareness Assessment. It's a 60-question assessment. It'll take you through maybe 20 to 30 minutes, and I highly recommend that people do it, because one of the games that I always like to play when I'm talking to kids in the K through 12 outreach that we do is I want them to spot the invention in the room. And people don't realize the very, very simple things that are patentable and have been patented. So you really do need to, I think, have a little bit of guidance, and I really like that awareness assessment because it helps you walk your way through where, all of the different parts of the intellectual property world that you might have. These are just a couple of things about how you develop an intellectual property strategy. If you're here at the university and you're working with NUtech, NUtech is going to help you with that and make you go through the process of developing that intellectual property strategy. One of the things that we always like to say at the Patent and Trademark Office is that, 50 years ago we were a nation of manufacturers. We are no longer that. We are a nation of thinkers. And the things that we think about and the intellectual property that we produce is actually our nation's greatest export. And there's a couple of really interesting statistics, but one of them is that IP-intensive industries contribute $5 trillion to our nation's economy, which is about half of our gross domestic product. So IP is important, and it's something that you need to think about. These are just a couple of things of ways that you can get value from your IP. I think this is probably the most important, either to obtain funding or to sell or license. When you're looking at the university setting and working with NUtech, that's definitely where they're going to be looking to help you move along in that commercialization. We have a study called The Bright Side of Patents. I recommend it for any of you who like to read really wonky economic studies. I'm happy to send it to you. These are the highlights. Early patent grants in a startup are shown to help create jobs, grow sales. On this one, I really do have to kind of call out because they say that, right, that a measure of innovation is the number of additional patents that you file. Well, I kind of think that that's a little bit self-serving, but we are the Patent and Trademark Office after all. But I do like this measure of innovation. So one of the things that you can always do to measure how innovative any particular patent is to look at the citations, both the backwards and the forwards citations that happen to that patent. And in fact, there are companies out there, I was just talking with the University of Colorado, and their tech transfer organization actually looks at the companies that cite to their foundational patents on research, and then that's how they target who they're going to go ask for a license. I thought that was interesting and showed some unique initiative. Then the other part of the IP, this one is the headliner, I think, from the study. It's that early patent approvals double your probability of being listed on a stock exchange, either through an initial public offering of your own or through an acquisition. Okay. It'll facilitate your access to VC. I think this is the big one to focus on here is that, an early patent grant approval can help increase your second round of funding by about 50%. This is the professional investor's viewpoint that's discussed in that study. And this is why patents are important. And I think, especially if you happen to be in a group of people that may be underfunded in the venture capital world, I think patents really help right here, which is that communication of the technical details credibly. When you have a patent that's issued or been granted by the U.S. Patent and Trademark Office, you have kind of that stamp of approval that your technology is useful, new, and non-obvious. So it's an advancement over what was out there before. And I think that's one of the ways that VCs actually look. And when I say VCs, I mean professional investors. I think that's one of the things that they really look at in being able to decide whether or not to fund a startup. It's just a couple more. So public disclosure examples, and I think this is probably something that all of you face. Demonstrations, description of your invention in a newspaper or journal article, offering to sell it, posting your invention to the internet, displaying your invention at a trade show. One of the examples that I always like to use is, I have this little, it's called a QB. By the way, it's really cool. But it's called a QB, and it's this under your desk bicycle. So it's supposed to help, because, right, patent attorneys sit down a lot because we're always looking at papers, and sometimes I get lost in the details and I forget that I've now been sitting for 4.5 hours, and that's like really bad for you, right? So I bought this QB, and it was the coolest thing. But I bought it through Kickstarter like 3 years ago. And they didn't have it. It wasn't invented, it wasn't manufactured, but they took my money. So is that the sale date, or was the sale date when they actually delivered the QB to me? And I think that's one of the areas of law that's going to be developing as we go forward in the Kickstarter or the crowdfunding kind of world. Because the case law is very specific, right? That it isn't actually a sale of an invention if you don't actually have anything to sell. Like if you actually have to create what it is that you're selling and experiment with it to figure out how it's going to work, you don't really have an invention then. And I have absolutely no idea if QB has patents, so it could be a non-issue for them. But it'll be really interesting to see about what happens with some of these Kickstarter campaigns or some of the other crowdfunding campaigns that you can see. In terms of just keeping it a secret, trade secret is one of the 4 prongs of intellectual property law. I think it's a very valid prong for a lot of things, but I mean, one of the things that you need to know about trade secrets is if somebody else can take your invention apart and reproduce it, it's a complete defense to the theft of your trade secret. So, and the other problem with trade secrets, especially when you're talking about either licensing to some sort of national or multinational company or something along those lines, is that trade secret law is a state-based law for now, although there is a bill pending in Congress to make a federal right of action on trade secrets. But it is literally 50 different nuances of what is a trade secret and how you're supposed to protect it and the steps that you're supposed to go through. So if you are planning on keeping something that you're inventing a trade secret, I would very much recommend that you get with an attorney to make sure that you can keep it a secret in all of the states or nations that you might be selling it in. So let's talk a little bit about what is patentable. Because I think the one question, as I've done more and more of these, I think there's a couple of things that come up. In the biotech world, it's always, well, what's patentable there? And then in the software world, I always get the question, well, are software patents dead? And no, they are not. Because when you talk about a method of making processes, method of using, improvements thereof, those are still patentable subject matter, and that is something that's worth talking about. We can get into those details, but it still has to be new, non-obvious, useful, and clearly described, because you still have to meet the requirements of the patent statute. But software is still definitively within that realm of patentable subject matter. It's just a little more interesting to do these days. IP strategies, you can take a look, and if you're working with NUtech, they'll help you with some of these strategies. Where you're going to file, what your claim is going to look like, your licensing strategies and control, defensive versus offensive strategies. Those are things worth talking about. When you want to file a patent application, that really is answerable in one sentence, which is as early as possible. When you're pretty certain that you have something concrete, that's when you want to be looking at filing, even if it's just a provisional. One of the things that we decided to do when we went to the first to file system is to set up a startup page so that those who are in the startup world can go to one location on our website and be able to find all of the resources that they need, including how to represent yourself before the Patent and Trademark Office, and also how to get a pro bono patent attorney to assist you with the patent application process. In Nebraska, this is the website for Patent Pro Bono help. We have law school clinics. I think Nebraska is one. Yeah.
There's a certification, but yeah.
Yep. And this is that IP awareness assessment. It's on our website. Micro-entity status, if you're working with the university, you need to talk to them about what status you can file. If you're doing something on your own, I think you can take a look at micro-entity status. These are the requirements for it. Let's see. We also have a process designed for issues and kind of to get some help. So if you have a pending patent application and you kind of feel like things have gone off the rails a little bit, you can call the patent ombudsman and they'll help you at least get it back on track and figure out what's going on with it. The other thing that we have is the Inventors Assistance Center. If you have any questions about the patent process filing, you can do that. This is our track 1 prioritized examination. So when we were talking about the bright side of patents earlier, it was definitely the, okay, an early patent approval is the thing that's most helpful for a startup. And this is the way that you can get an early patent approval. You will get, the thing that we guarantee is that you will get a determination, a final determination on your patent application within 12 months of the date that your petition is granted under track 1. And we've actually been coming in under, the statistics show that we're probably around 7 months at this point, which is huge. It's an extra fee, but it may well be worth it if you're looking at, it's a relatively small extra fee compared to the overall filing of a patent application. We talked about the grace period. We talked about filing as soon as possible, and then these are some of the resources. And then let's go ahead and open it up for questions, because that's always my favorite part. The talk that Brad was referencing in Omaha, which went for, I think, 3.5 hours, I got 10 minutes into the presentation, and then the rest of it was just Q&A. So does anyone have any questions? Yes, sir.
This may seem like a dumb question, but what's the best place to go to research other patents? Like the best online source?
Okay, so 2 places. I would say work with NUtech if you can, because they will help you get through that. Well, and I'll just say 3, because I do have to do a plug for my office. Yeah. If you happen to be in Denver, come to the office. You can use the same search terminals and search databases that our examiners use in our public search facility. But the other place that you can do that is at the Patent and Trademark Office resource centers. And there is one here, and it's at the University of Nebraska.
The engineering library.
At the engineering library. And there's a trained librarian there who can help you get through the system, design a search, get through and look at the prior art, right? Just again, as a caveat, this is one of those things, whatever you find in your search, make sure that you keep track of so that you can then disclose it to the Patent and Trademark Office later, because that's one of your duties as an inventor. Yeah. But we'd love to see you in Denver. Just come visit us anytime. Yes, ma'am?
Will that show all the patents that are pending, or just the finalized patent?
It'll show any patent application that's been published, okay? So when you file, well, let's take it from, I guess, the beginning. If you file a provisional patent application, you have 1 year from the date of your provisional application to file a utility application. In that sense, 6 months after you file your utility application, it will be published as a published patent application. If you file utility first, that time period is 18 months. So basically, it's always 18 months from the date of your first filing, whether it's a provisional or a utility. But yeah, the prior art, so there's an 18-month gap, but it's still pretty accurate.
So how much extra fees for the fast track one?
For a large entity, it's $4,000. For a small entity, it's $2,000. For a micro entity, it's $1,000. I know. And then the guarantee right is from the date that your petition is granted, you will receive a final determination on your patent in 12 months or less. We've been averaging about 7. Yes, sir.
How long in general do it takes for you to make a decision on patent application?
I love when people ask me that. Because I get to give you the lawyer answer that I always used to give my clients before I came over to the federal government. And the answer is it depends. It depends on what technology center you're in. It depends on what art unit you're in sometimes. It depends on what the backlog is for that particular set of technology. It can range anywhere from 18 months to 5 years.
5 years.
If you're in the business method world.
Okay.
Yeah. Yes, sir.
On your diagram, you had the improvements thereof,
Uh-huh.
things like that. Could you speak just a little bit to that? Because generally what they like to do is like for our art. So how do we write something up that gets it through the patent process?
So if there's something foundational that's out there, and maybe I'll use MIT's Maser program, right? Because that was basically one of the first sets of optical lasers that was created. There were, I think, about 40, foundational patents that were associated with that particular foundational invention. Over 5,000 have been filed afterwards on improvements of doing it. Innovation, I think, is always an incremental step. You can take a look at, the cell phone. Just look at the iterations of the cell phone, the generations of the camera, and there's patents associated with each one of those generations of the cameras that are in your iPhone.
So the idea is to be just really straight in the patent application that this is an improvement thereof.
And yeah, and you can say, I don't have a good example right now, but right, like you can say, a camera for placement inside of a phone, and then whatever you invent has to be something that step above that makes the camera better from a technological perspective, and not obvious. And that's the key, right? Because that's our statutory authority. We have to determine whether or not the patent applications that come before us present something that is useful, new, and non-obvious.
And can you make, use, and sell that technology necessarily in all cases?
Not necessarily. Okay, so that's actually a good question. You may not be able, right? If your invention relies so much on the foundational patent, and that's owned by somebody else, you may very well need to take a license to their patent. But if your improvement does something that they didn't think about doing, then they may need to take a license to your patent in order to advance their technology as well. And in those situations, that's something that we call a blocking patent situation. They get really technical really quick, but we're happy to have that conversation. And I know Brad in particular is very happy to have that conversation. So, but it's an interesting situation. You just need to make sure that you're looking at, whenever you're using somebody else's intellectual property, you want to make sure that you have the ability to use it and the license to be able to do that.
So as an examiner, how much data you look for in the patent application in terms of like, has the prototype being built, tested,
We don't care about that.
validated, any of those is important? Just the idea,
Mhm.
whether it works or not.
I would not recommend filing a perpetual motion machine, because we're pretty sure that's not possible. But, no, right, the U.S. Patent and Trademark Office is not in the business of judging whether or not a prototype is there, whether or not it works. We take your word for it that you've determined that, it works. And that's part of the technical description in the patent, right? There's several different parts of a patent. One is the title, there's the specification, there's the detailed description, and then there's the claims. The claims are what the patent office examines to determine whether or not they're enabled by the specification, and then whether the claims present something that's new, useful, and non-obvious.
Keeping in mind that you're talking with an expert in a particular technology area when you're trying to get the patent.
Yeah.
So,
Right.
so they'll know if you're making something up.
Yeah, most of our, well, depending on the technology center that the examiners are in, but we've had examiners who have been in their particular technology area for 20 plus years. They've seen a lot. Yeah. Any other questions?
So when we file through the fast track system, so you go and search against all the provisional patent applications to figure
No.
out who is.
Provisional applications are not searched, examined, or looked at in any way, shape, or form by anybody at the Patent and Trademark Office. You get a placeholder with a provisional patent application, and that is all you get.
So it's not considered as a first to file.
No, it is, because it gives you the date. It gives you your filing date,
Okay.
but no one takes a look at that provisional patent application until you convert it to a utility application. You look like you have a question.
Yeah.
Okay. Like,
And there be any difference between the utility application and the professional application and the specification?
you want to be careful about that, right? Because what you're setting up there is a situation where your utility application is going to have what we call new matter, right? That doesn't match the provisional patent application. So one of the things that you want to be careful about is your provisional application really does need to match what you disclose and what you claim in your utility application, or the stuff that's new gets the utility filing application date. The stuff that was old gets the provisional, and someone else may have come in that time frame and covered all of it. So you really do, when you're doing your provisional applications, you want to be careful about the scope of your provisionals, because you want to make sure that you are claiming, when you don't use claims in provisionals, but you're disclosing the scope of your invention so that you have the ability to write a utility application later that matches that scope. Yes, sir.
I'm studying biotechnology, and then I know that there's some patent war between Harvard and the researchers in Berkeley, specifically for the Cas9.
Okay.
Yeah, and then I heard that even before filing a patent, you should certify all the ideas and everything, even in your lab notes or the files in computer. Is that really necessary, even before filing the patent?
So
In case of the patent conflict or because I know the initial inventor was the group in Berkeley, so the Harvard group they process the patent faster than the Berkeley group. So now they're claiming they're the original patent holder. So it's been a big issue. It's a messy.
Yeah, that's
And one of the things that you're talking about is something, right, when I started as a baby patent attorney, inventor notebooks were really, really, really important because we were under a first to invent system. Under the first to file system, the time when your inventor notebook might become evidence in a patent infringement litigation is going to be pretty rare, because it's all going to be based on the filing dates of the applications. But I always recommend the use of an inventor notebook, because if you're like me, we were just talking about this last night when we were driving. I can remember the words of every single 80s song that I loved when I was a teenager. I can't remember what I had for breakfast. So, it's, I always recommend using inventor notebooks just for the sole purpose of keeping my brain organized and keeping my inventors and my engineers' brains organized about when we talked about something, where the idea came from. Because a lot of times when you go back and you explore those, it's also, you find the prior art, and you get yourself into, that kind of mind frame again. So I like inventor notebooks. I think they're great ideas. I don't know that they're necessarily the evidentiary tool that they used to be in the past.